Hello everyone and welcome to today's video discussion. Today, we will be delving into Section 16 of Article 3, Bill of Rights. Section 16, Article 3 of Bill of Rights stated that all persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. Now, this right applies to everyone regardless of their status or circumstances. It is a universal right for all individual in the Philippines. Okay, what is speedy disposition? When we say speedy disposition, it refers to the idea that legal and administrative matters should be resolved promptly and without unnecessary delays. When we say judicial, these are traditional courts such as regional trial courts, the Court of Appeals, and the Supreme Court, where legal disputes are resolved through trials, hearings, and judicial decisions. When we say quasi-judicial, these are specialized bodies with the authority to make legal determinations and decisions in specific areas, like the Ombudsman in cases of government corruption or the National Labor Relations Commission or NLRC in labor disputes. When we say administrative bodies, these are government agencies responsible for implementing and enforcing laws and regulations within their respective areas. They can make decisions on various administrative matters like licensing, permits, and regulatory compliance. Okay. Section 16 of the Bill of Rights emphasizes the importance of timely and fair resolution of legal and administrative case for all individuals in the Philippines. Violation of this right can lead to legal actions, and while there may not be a specific Republic Act addressing such violations, remedies are available through the judicial system and other relevant laws. Article 8, Judicial Department, Section 15, stated that all cases or matters filed after the effectivity of this Constitution must be decided or resolved within 24 months from date of submission for the Supreme Court, and unless reduced by the Supreme Court, 12 months for all lower collegiate courts and 3 months for all other lower courts. When there is a violation of this right, what is the rule? Dismissal of the case for violation of this right is the general rule. We have the maxim, justice delayed is justice denied. Also, if it is violated, the aggrieved party may file a petition for mandamus to compel the court to act and expedite the proceedings. Mandamus is a judicial remedy in the form of an order from a superior court to any government subordinate court, corporation of public authority. Second is dismissal of charges. In severe cases of violation, the court may be ordered to dismiss the charges against the accused. Third is suppression of evidence. Evidence obtained in violation of this right to speedy disposition may be inadmissible in court. Fourth is disciplinary action against judges. Judges responsible for causing unreasonable delays can be subject to disciplinary actions, including reprimand, suspension, fines, or even removal from office. This right is deemed violated only when the proceedings are attended by vexatious. It must be intentional, deliberate, and designed to harass or oppress the accused. Capricious, it must be arbitrary, whimsical, and without any rational basis. Oppressive delays, it must be cause prejudice to the accused, such as anxiety, stress, or the loss of liberty. Moreover, the court mentioned certain factors that should be considered and balanced when determining whether the delays whether the delays are of said nature is relative and cannot be based on a mere mathematical reckoning of time. First is the length of the delay. Second is the reason for the delay. Third is assertion or failure to assert such right by the accused. And fourth, prejudice caused by the delay. Okay, the essence of this is to ensure that justice is not delayed unreasonably and that individual cases are resolved fairly and promptly. Violations could lead to legal actions, appeals, or petition aimed at securing the speedy disposition of their cases as required by the Constitution. RA number RA number 8493, the Speedy Trial Act of 1998, Rule 110 of Revised Rules of Criminal Procedures, Time Limits for Trials and Hearings, Administrative Code of 1987, Time Limits for Administrative Proceedings, are some example of special laws and rules of court with disposition provisions. Okay. When must a judge resolve or decide a case? The Constitution Code of Judicial Conduct and Jurisprudence consistently mandate that a judge must decide a case within 90 days from submission. Section 15, Article 8 of the Constitution states that judges must decide all cases within 3 months from the date of submission. A judge is mandated to render a decision not more than 90 days from the time a case is submitted for decision. Judges are to dispose of court business promptly and decide case within the period specified in the Constitution. That is 3 months from the filing of the last pleading, brief, or memorandum. Failure to observe said rule constitute a ground for administrative sanction against the defaulting judge. Okay, the 90-day regulatory period is mandatory. Failure to decide a cases within regulatory period constitute a ground for administrative liability except when there are valid reasons for the delay. Please take note that the right to a speedy disposition of cases is different from the right to a speedy trial. While the rationale for both rights is the same, the right to a speedy trial may only be involved in criminal prosecutions against courts of law. This right to speedy disposition of cases, however, may be involved before any tribunal, whether judicial or quasi-judicial. What important is that the accused may already prejudiced by the proceeding for the right to speedy disposition of cases to be invoked. Thank you.